Hey guys, what is up? It's Dusty here, and welcome back to another crypto video. And today I am interviewing a very famous soccer player, and his name is Marco van Basten.
No, just me, Dusty.
Oh, I thought it was Marco van Basten. I guess same type of qualities, huh? Same type of skills, most
I
likely.
appreciate it. You know, you booked Marco van Basten, you get me. Here I am. So.
I'll settle for it. If only Ripple could do that, huh? Now,
Yes.
so quick introduction for everybody who doesn't know, which I think is, I mean, who doesn't know this man by now? This is Jeremy Hogan. Give us a little introduction about how you got to this conversation or Zoomy here. You are XRP talker.
Yeah, so I was not really into crypto until last year, really. When the pandemic hit, you know, everyone had a little free time, so I started to do a little research on cryptocurrency. I was really looking into Ethereum because I do breaches of contract and that type of thing. And so I was very interested in smart contracts because you kind of take out the middleman, and that was very interesting to me. But then, you know, it just evolved into something more when I saw that the SEC had filed the lawsuit against Ripple. And I started looking into that, and I saw, you know, really what happened was I saw a lot of negativity online about it. There was a lot of people that were saying, oh, it's doomsday, you know, Ripple's done, XRP is done. And I look at the lawsuit and I was like, yeah, that's just not the case. So I did one video on it in early January. And I said, you know, this is not an easy case for the SEC. And I think, you know, the XRP community kind of picked up on that, and then kind of we went from there. So it's really a passion thing for me. The XRP community is so supporting and nice, and they're just very grateful for everything that you do. So it kind of gets you into it, so you do more and more and more. So
yeah, that's very
kind of how it goes.
But then, so that was like your first introduction to crypto then at the start of like the pandemic, I guess, or like when they got sued is when you first got into it, or?
Well, I bought some Ethereum, and I was really interested in the whole idea of a smart contract because.
Yeah, but when did you buy the first Ethereum? Like what year?
That would have been just like, yeah, that was last year.
Oh,
that
okay.
was around March.
Wow, so
yeah.
you're crypto newbie, huh?
Yeah, I had some friends that were doing the Bitcoin mining and all that, so I knew kind of generally what was going on, but I really didn't dig into it until I had some free time.
All right, Jeremy, and we've actually been getting a ton of questions about your wife, and I mean, how's she doing?
Dusty, what wife? Don't you know I'm a single guy? I'm, you know.
Little fun fact, you know that in 2017, a lot of the comments on my YouTube videos were always that XRP was a centralized piece of garbage. And so when they actually got sued, the first time around, there was so many comments said, oh, that makes a lot of sense. That's what's supposed to happen. It's clearly security. Does it make sense to you in your own like personal opinion? The case, right?
You know, in hindsight, it's starting to make more and more sense, isn't it, Dusty? I mean,
yeah.
At the time, it didn't make any sense because you're like, where's this coming from? But some of the things, and I stay away from most of this. There's a lot of guys that are talking about it. You know, John Deaton is all on top of it. Digital, all these guys are really on top of this. So I stay back from it a little bit. But as you see more and more what was going on a little bit behind the scenes at the SEC, the lawsuit starts to kind of make more and more sense. But I'm always struggling with what the legal significance of that is. So I don't really talk about it much in my videos because I'm really not quite 100% sure how it's going to play out legally. So I just kind of stay away from it.
Yeah.
But, you know, at first, the lawsuit didn't make sense because there's a lot of easier targets than Ripple XRP out there.
Like what?
And well, like, for example, the Kick Interactive token was sued. That was an easy target.
Yeah.
But really, you have 90% of the ICOs back in 2017 were very arguably securities. I mean, that's the easiest case. You took money from someone in order to develop a coin, and there was nothing there. You took the money to develop the ledger. That's the hallmark of a security. Ripple didn't even have that hallmark. Ripple, the ledger was already there, and then Ripple was formed. So there were much easier targets for the SEC back in 2017, yet they chose Ripple. And why that is, I don't know personally, but I think you could see with some of the things that are coming out recently about what was going on behind the scenes, that we might be getting an inkling of why that happened.
Yeah, I'm assuming you're talking about the whole Ethereum, Joseph Lubin, the John Deaton digital asset investor digging that they're doing. I've seen
Yes, exactly. And they're doing such a good job. I don't even touch it, but you know, I'm just having a hard time in my mind. You know, a lot of the judges don't see themselves as ethics judges. They're there to decide a certain legal issue. And I think the judge in this case, I haven't changed my mind yet, that I think the judge is going to stay focused on the fair notice defense, damages, and on whether XRP is a security. I'm not sure how they're going to get all this, or if they're going to even try to get some of this stuff in front of the judge. That doesn't mean it's not important, because there's more here going on than just this lawsuit, and it could be very important in that realm. But I'm still struggling with how these type of issues get in front of the judge.
No, and what, because I know a lot of people here are confused because you use a lot of kind of the more legal terms as well. And for example, you said ethics as an example in the lawsuit case. What do you mean with that exactly? Just for the people.
Well, part of the argument, I mean, part of what John Deaton and those, the Twitter sleuths, Brad Garlinghouse called them, part of what they're doing is finding ethics problems, because, for example, someone working for the SEC and then going to work for, working at the SEC, taking an action that affects Ripple and then going to work for one of Ripple's competitors is generally not illegal. Like, people don't really go to jail for that, but it's generally an ethics problem, especially if you're a lawyer, to have those type of conflicts of interest. So in the past, I've been involved in lawsuits where there have been ethics violations by the lawyers. Let's say a lawyer tries to hide evidence or something like that. You don't go to jail for those type of things, but you can get in trouble with the lawyer licensing board or the lawyer licensing commission.
Okay.
So those type of things, judges generally don't get involved. And I've had issues where those type of things have been brought up in front of the judge, and the judge said, you know what, I'm only deciding this issue. I'm not going to be talking about ethics. And I think that might be where all of these issues are heading. But like I said, this is more than just this lawsuit. This is about the SEC and how they do what they're doing. And those things, even if they don't affect the lawsuit, will affect other things that are maybe even more important.
Okay. So from that perspective, one of the questions that was brought up very often is there any way in which the nice cup that I always see in the videos, or is this a different one? I always see a cup.
Never cup.
No, too bad. A lot of people ask, is there any benefit for the SEC or their lawyers to sue Ripple for them, like a little bit more on a broader scale? Like, people have been asking, what do they actually have to gain? Because, for example, Ripple have to pay. Where does that money go? If you get my drift, if they were actually
my understanding is that the money goes into the general federal coffers.
Okay.
So I think there's some misconception that it goes to the SEC directly somehow. Definitely that I don't think that's happening, and definitely the attorneys for the SEC are not getting bonuses based upon how much money they bring in. But even though the money is going to the general coffers, the SEC has to justify its existence. So of course the SEC wants to go to the government and say, we brought in $1 billion this year and our funding is only $500,000, so give us more money for funding.
Okay.
So there's that. Also, I think the other thing that I haven't heard talk about too much here is, and I'm veering off topic a little bit, but as to clarity for cryptocurrencies, if you think about it, there's not really much incentive for an SEC attorney to want clarity in the market. And the reason why that is because, and you're going to see you're going to see it even in the Ripple case. Half of the attorneys that are working for Ripple right now used to work for the SEC, right?
Yeah, I've seen that. Yeah.
Solomon, Mary Jo White, all the attorneys, half of them used to work for the SEC. So in a sense, what's the incentive? Okay, so what's the incentive for an SEC attorney to want clarity in the market? Because they're really just kind of cutting their own, benefit of moving on into the private market and making a lot more money.
Okay.
So, and I'm not saying that this is a conscious decision where they're like, we don't want clarity, but really the general flow of things as you work for the SEC, you learn how they think, you learn how they act, you learn securities laws really well. You're not making a lot of money. I've seen how much they make. It's not a lot of money in the legal world. But after you do 5 years at the SEC, then you get the job at the big law firm representing the Ripples of the world. And now you're making 5 times as much money. And the reason why you're able to make that much money is because securities laws are so vague and so complicated, and no one really understands it except for you because you've spent 5 years at the SEC. So
Yeah.
that's something I haven't really heard people talk about too much. But from an incentive standpoint, I think it's important to understand that there's really no incentive for anyone at the SEC to want clarity. So I think that's kind of a big problem.
And in the same sense, because I got these questions connected now in some way, shape, or form. By the way, for everybody watching, I have like a list of things I wrote down from everything that you guys said in the comments section, but also on Twitter. And now I don't remember the name. I didn't write it down. This was lawyer question. Since we gotten bombshell footage of Gensler himself admitting XRP had no clarity, why isn't the case finished based on the fair notice defense? Can that be ruled on now, or do we have to wait for summary judgment? I'm not actually sure, but
yeah, that's a great question. And I see that on Twitter a lot, and I just don't have time to respond to everyone, but the judge can only rule on an issue that is properly in front of her. If let's take, for example, my case that I just finished. The other attorney called and conceded about half of the case right before the trial, but that issue had never been improperly in the judge up to that point.
okay.
So he knew that he was going to lose on it the next day, so he just conceded, so he didn't have to go through the losing of it.
Okay.
So the judge, meaning the judge can only rule on what's properly in front of the judge. So in order, there's only two places a judge can throw out a case: at a motion to dismiss, which is still pending. Now the judge could have ruled on that, but she hasn't yet. And then also at summary judgment. Those are the only two places. A trial would be in front of a jury, and that's not something the judge would rule on.
Okay.
So in order for Ripple to win on the fair notice defense, it has to file for summary judgment. You can only file for summary judgment when all of the discovery is complete, and not all of the discovery is completed. That's not going to happen until next month, I think, or early November.
Yeah, November 13th, I think.
Yeah, so people get kind of impatient with it, and it's like, well, if the case is so great, why can't the judge just throw it? She can't, because if she did, she'd be overturned on appeal, and the case would end up back in front of her again, and she would look bad. So basically, you have to wait for discovery to finish. Then all the parties get a chance to brief everything. There's going to be really big summary judgment briefs with thousands and thousands of attachments, and then she can rule on it. But she can't do it until then, because that's called due process, and it's part of the Fourth or Fifth Amendment to the Constitution.
I've read about it.
Yeah, but if you don't follow those steps, you're not getting a fair trial. Now, the SEC has the right to have a fair trial as well, right?
Yeah, obviously.
So just because the judge looks at stuff and is like, oh, this case is going to lose, she has to wait until it's all briefed, all the information's in front of her, and then she can rule on it.
So on the last decision, she basically said that we are not going to be able to look into the SEC's pockets, basically, or the members' pockets for the XRP that they held, right? You saw it, right? The most recent denial motion a couple of days ago.
You know, I know that got denied, but I haven't read it yet because I was prepping for this trial this week. So I'm a little behind.
No, I mean,
so she said that like the XRP that holders have cannot be touched in this lawsuit.
So, well, she basically said, let me actually grab it here. Defendants' request for documents reflecting the SEC's trading pre-clearance decisions with respect to SEC's employees' transcripts in Bitcoin, Ether, or XRP, and annual certifications concerning SEC employees' XP holdings is denied. And then a side note was the court directed the SEC to provide defendants any documentation supporting SEC counsel statements during the August 25th meeting confer that after the formal order of investigation was issued as to Ripple on March 9th, 2019. SEC employee could no longer trade XP. My personal perception was she basically now ruled in this letter from March 2019 on forward, SEC employees could not trade XRP anymore. And before that, there's another 2018 date when something changed. I don't remember exactly what about it. But the people have been asking me like crazy, why did the judge deny such a critical piece of info? Because they did ask for Brad Garlinghouse or Chris Larsen's financial infos. Now, apart when they wanted to get every single detail out of them, she denied it. But the general gist of it, and even all other Ripple employees, they did get that approved. So why not the SEC? Like people have been asking like crazy.
Yeah, that's a good question. Now, I do know the motion you're talking about, and I do know it was denied. I haven't read the judge's opinion yet. But
oh, that was what you mean. Okay, sorry.
Yeah, but let me say that I'm not surprised it was denied, and I think that probably, I don't want to make anyone mad, but that was probably the correct decision. And the
Oh,
reason for
I can already see. Oh, just Jeremy Hogan, get him off my channel. Yeah, get him off the Justice. He's very
Yes.
fud. Yeah, I can already
But
smell
look,
it.
I thought the SEC was going to win on one of the earlier motion, and I was correct in that, and I thought so on this one too. I just didn't like say it, I guess, anywhere. But
Yeah,
the reason why is because if you were at the last hearing, we're dealing with an objective standard, right? It's
yeah.
on the fair notice, what did the marketplace think? And that's an objective standard, not what did Brad Garlinghouse, Chris Larsen, Ripple think. What did the marketplace think?
Yeah.
So only information that was communicated outside of the marketplace really is relevant.
Oh.
So, and I'm just guessing where the judge is coming from, but this is what I would have ruled if I was a judge. I would have said, look, this what the trading practices of individual SEC employees is their private information, and it's not dispersed outside of the SEC.
Yeah.
Therefore, it's not relevant because it's not dispersed to the marketplace, and it's an objective test.
Okay, but then this is my own personal understanding, not the questions. Isn't it about if the SEC employees, like for example, Gensler, who's only now an employee, but I'm talking about people before, are trying to say it's so clear, yet they, for example, are holding XRP themselves at one point or another, then they can never make this recklessness argument that Ripple should have known, right? I mean, that makes sense to me in my head. So,
well, I think, and again, I haven't read it yet, but I think that whether or not they were allowed to trade XRP, the SEC is being forced to disclose. They're not.
Yeah.
I think the judge is only denying Ripple from obtaining individual SEC employees'
true.
amounts and what they owned, and that.
But even in aggregate form, it was denied. Aggregate was also denied. So nothing. They're not going to get anything. Only the information as to how they came to the conclusion that from 2019 forward they could not trade anymore. That was discussed in the meeting for the 20.
Then I would disagree with that if that's what a ruling is. But let me take a look at it. And
yeah, well, I get that. Sorry for kind of getting that question up front already. I understand you're a busy man, but I thought you were a little bit more up to date. Amateur. No, but
give me a day.
But the John Deaton thingy, that's also one thing I saw so often, that John Deaton wants to intervene. When in the world is the judge going to make a ruling on that? It's been so long.
I don't know. It's a frustrating thing, and I know it's frustrating for John because he's been waiting so long. But I think, and I don't practice up in New York. I only practice down here and really in Central Florida and a couple other courts. But I think that up in New York, the way they do it is, I don't think they rule on too many dispositive motions until discovery is completed.
What does that mean?
That means, okay, so we did fact discovery where they do the depositions and they get the documents, and we had all these arguments recently. So the fact discovery lasted until a couple of weeks ago, and now they're doing the expert discovery. That's going to close in November, early November. I think it stops November 12th.
Oh yeah, could be.
I think in New York, what the thought process is, let's let the attorneys get all the information so that they know everything about the case, and then we're going to rule on everything important. Okay. So John's motion is important. The motion to dismiss, Brad and Larsen have the motions to dismiss still outstanding. They could be dismissed out of the case altogether. Okay. The SEC has its motion to strike the fair notice defense. Yeah. So I think the judge is going to wait till after November. I mean, she would have done it by now if she was going to do it. So the only thing that makes sense is she's going to wait till discovery closes, and then she's going to rule on all the important things.
And we also have the motion that's the motion to compel, like the SEC documents, right? That where Ripple's going to reply the 28th, if I'm not mistaken. What was caused from the hearing?
Yeah, that's not a dispositive motion. So that'll be ruled on by Judge Nipper. And I think Judge Torres is only getting involved once discovery's closed and all that's finished.
Can you actually explain that real quick? So there's two judges. What is the difference between those two judges?
So the first, Judge Nipper, is the magistrate judge, and Judge Torres is the judge, I guess. Yeah. The magistrate judge is essentially really what she deals with is discovery issues. The most of the work in a case, let's say you have a case that lasts 2 years. Yeah. Well, 22 months of it is discovery. So you spend 22 months on discovery and then 2 months on all the important things. Yeah. But those discovery motions are all important, but one judge just can't handle it. It's just too much. So Judge Netburn is going to handle all of the discovery issues, all the fighting on what documents are produced, this and that. At some point here soon, she's going to hand it over to Judge Torres, and we're going to hear more. This case will be handed over to the judge, Judge Neprin will step back. So we've been hearing from her recently, but here in the next month or two, there's going to be a new judge that's going to take over, and she's going to be the one that's going to take the case from that point forward.
Any expectations on her? Like, do you estimate her to being more biased towards a certain side? If you know what I mean? Like,
I did a video about her. I liked what I saw. She's in her early 60s, mid 60s. She looks young, young-ish for a judge, you know.
Yeah.
They're all kind of gray haired. But so the thing I liked about her was there was a hearing I found online that she did. And what happened was there was some problems in the New York prison and with the conditions of the prison. She actually went to the prison with a court reporter, and she went inside and she was interviewing inmates about their condition. And I kind of like that because that means that she really cares. She wants to understand. She's not just going to sit back in her chambers and write an order. She actually went to the prison. She was interviewing the prisoners. You know, you could see the transcript online. So that kind of made me feel good. You know, these cases are difficult though for judges because it's hard enough. It was hard enough for me to really get a good handle on what cryptocurrency is all about.
Yeah.
And the older you get, let's be honest, the harder new technology becomes to wrap
Understandable,
your mind around.
definitely.
Yeah, I think Judge Neprin has done a pretty good job with it. She obviously got a handle on it, but we haven't seen what Judge Torres is going to do with it yet. We're not sure if she's going to be able to get her mind around what's really going on here.
So we'll have to see.
We just, you know, keep your fingers crossed that she can do that.
Okay, but I guess let's see. Now, quick intermediary question: how's the garage band doing?
So, Hogan and the Cluckers, that's what we're calling it.
That's gonna be the name.
Yeah, I mean, I thought I was going to retire there for a while and just be a garage band, but I got pulled out of retirement. So it's going slow. My guitar playing is horrid. My singing is even worse. So I'm trying to recruit BitBoy for play the drums in the band, but I haven't heard back from him. So
No, not yet. Maybe we'll see. Indeed, we'll see. It's gonna be pretty special. Okay,
you play an instrument?
I used to play the French horn. Little fun fact. I don't know. I think it's French horn, and in Dutch is just normale horn. I never heard.
Is that the one that's the
Yeah, exactly that one. Fun fact, huh? Nobody knows that. I used to play that. There's different instruments I played, but not that. You know, like I can play violin, I can play piano, I can play a lot of things, but that's my main instrument. So
one regret growing up is I never really learned an instrument, and that's always been something I regret. I mean, I could play a couple chords on the guitar, but that's about it. You know?
No piano?
No, but I got my girls playing piano. They're actually getting pretty good. So
yeah, well, that's cool. Maybe, but what do I say? Exciting, cool, nice. Is it nice? Is that impressive?
You know, once you have kids, it's nice to be able to give them something that you never had. I will say that.
Piano skills.
That is a cool thing.
Skills, yeah, I see.
Yeah, so like you're gonna have kids, and you're gonna back on things that you're like, you know, I wish I did that, and then your job is to make sure your kids do that.
Oh no, I have 28 kids. Never.
Okay.
No, okay. So yeah, we'll get further on with the question. So one thing I also saw very often was, can we, or U.S. citizens or something like that, actually sue any SEC or employee or lawyer in any way, shape, or form? I've seen that question come by, let's say, at least a dozen times in a little bit of a different form every time, but you get the picture, I think.
Yeah. So it's a good question, and I understand where it's coming up. So in the US, and I think this is a pretty, well, in any common law country, we have a concept called sovereign immunity. And basically it means that the king can do no wrong. It's something that transferred across the Atlantic from Britain. And the idea is that you cannot sue the sovereign. So you cannot sue the state or the country. And the SEC is part of the federal government, I believe. So we cannot sue the SEC unless the SEC allows us to sue them. And I know it sounds silly because who would allow you to sue them? But it happens. Like in Florida, we sue the Florida government, but only under certain conditions and things.
I've never heard that before, that that's possible. That's very strange.
Yeah, it is. But in a sense, it kind of makes sense because really, if you sue the SEC and you win, you're just taking money from the federal government back to private citizens, which I guess that does make sense. But point being is they've set the bar very high. So is it possible? Yes, it is possible. But you almost have to show, I don't want to say gross negligence because that's not the exact.
Just verbiage, a very high bar, you're saying. I get that.
They almost have to intentionally mean to cause harm.
Okay.
And so it's possible, but very difficult, almost impossible to prove.
Yeah, I understand you completely. Very difficult, but theoretically speaking, possible under the right circumstances. So
Exactly.
in this case, most likely not. The baseline is probably not, very, very maybe, kind of.
Well,
So
John Deaton, he's crazy enough and brave enough to give it a try. So.
I believe you 100%. John Dean seems like the guy who would just try it anyway, just to see. Because I mean, he wants to really get back for the XP community. It seems like he wants to try everything humanly possible to get something, to squeeze something out of them, to admit that they were wrong or something like that.
So, yeah, what he's doing is really cool, because it's a lot of work. I don't know if people understand. If you haven't done it, you don't understand how much work that is.
I don't think anybody understands, actually. Can you give some estimate in any way?
I'm sure he spends a couple hours a day on this case. I mean, I spend about half an hour just to keep up with things, while I'm doing my legal practice. John has his own practice. He does his own work. He has a caseload over here. I'm sure when he wrote that brief, it took him, days, not hours, days to draft it.
Wow.
To get it ready. If he'd admitted, I'm sorry.
No. So do you work on, like, for example, right now, he's not writing anything, right? So what do you work on then? He's just researching stuff for the next thing to write down, if you get my drift? Like, what does he do in the meantime now?
John?
Yeah, like, because you said he looks at it every single day for hours. Is there something else which he has to write down now, like for the next preparation for this new motion to intervene? Or does that come only once it's accepted?
I say, yeah. So as far as pleadings, what he's drafting, he might be working on an like some kind of brief that he would submit to the court. But like a lot of what he's doing right now, I could tell from Twitter, is he's gathering information. He's saying, hey, if you own XRP, or if you're using XRP for your own use, or if you're buying things with XRP, let me know, because I want to incorporate that in what I'm going to show the court. And some of what he's done and gathered has already made its way into the pleadings. You see Ripple referring to it in some of its earlier briefs. So he's doing that. He's learning the law, because John is not a securities lawyer, neither am I. Okay. So, but we're both reasonably intelligent guys, and we could read English, and we could we know how to apply legal tests. Okay. So English, yes. He spent the last 6 months basically turning himself into a securities lawyer, and that takes some time. It took a lot of time for me as well. So all those things take time, and he's very involved on Twitter. Because that's part of how he engages with the XRP people. So yeah, I'm sure between all that work, he's spending an hour, 2-3 hours a day just on the SEC Ripple case.
Damn, 2-3 hours. I spend the same time, but I'm just goofing around, I guess, huh? He's actually doing real prep work. I can't even imagine the amount of work he has to go through once it actually pulls through the motion to intervene. It's going to be some.
Yeah, he had to learn, generally speaking, a lawyer practices 5 years before they're good at an area of law. Okay. So he had to cram 5 years into 9 months.
5 years. Yeah, he's been doing. He's been killing it, really. But to make sure I keep the thing flowing a little bit, one thing I also saw: this is a literal question? Can XRP still win a fair notice defense, even if XRP was a security, even though it's not? Just imagine it is.
Good question. So that is the definition of an affirmative defense. The fair notice defense is what's called an affirmative defense. That means even if we lose, even if XRP is a security, Ripple is not liable because they did not have fair notice. So that's the very definition of an affirmative defense. And I'll give you another one, like something that not you personally, but maybe people relate to better. So let's say I get in a fight with someone and I punch them in the face.
No, that's me. That's me. Yes, for sure.
Yeah, okay. So that's battery, right? That's a battery. Okay. I've committed a tort. I've committed a crime, really.
Yeah.
So I go to trial and I say, yes, I did punch him, but even if that's true, he punched me first. And so I have self-defense as an affirmative defense. Same thing. Ripple says, yes, maybe if you find XRP as a security, that's fine, but we still win because we didn't have fair notice.
Okay, I think a lot of people are happy to hear that that's actually a possibility, because I think the sentiment or the comment section switched a little bit from being mostly all positive to people saying it's taking forever, and because it's also quote unquote corrupt, Ripple is surely gonna lose. Then again, there's still an objective standard to be followed, I guess, huh? Because you still need, the SEC needs to show that Ripple kind of should have known, right? That's still they have to do like as a fact. But on the same sense, is a settlement still possible? Like, oh, guys, I kind of talked a lot there in 1 second. Huh?
It's okay. Okay, so first question first. Is a settlement still possible? Absolutely. And I know Ripple recently told Mr. Gasparino, is that the reporter's name?
Yes.
That they're not talking about settlement, they're not thinking about settlement, and that's fine. But I guess in what I said on Twitter is you never tell the other side that you want to settle. As soon as I tell an insurance company or whoever I'm dealing with on the other side I want to settle, they know I'm weak.
Yeah.
You never say you want to settle. It's always I'll see you at trial. I'll see you at trial.
Yeah. And shows strength, huh?
And then inevitably, or most of the time, there's a phone call. And I know when it comes because I get the other attorney calls me, hey, Jeremy, and he's very nice, nicer than he's ever been before. And now I know, okay, something's up and this case might settle. So this case could always settle at any time. My point has always been basically that there's probably not going to be a settlement until discovery is concluded, because only after discovery is concluded do each side know the strengths and weaknesses of their case completely.
Yeah.
Okay. I mean, the SEC, I'm sure, went into this thinking this is a simple security case. Is XRP a security? And then it got dragged down this fair notice defense road against its will. It didn't want to go down that road, of course. And now that it's been thrown down that road, now they have to reassess the strength of their position. And so only next month will they really know how strong their position is. They'll hire experts. You know, they're going in on an argument that the XRP ledger is not decentralized. Well, this next month, there's going to be experts testifying about how decentralized it is or not. And only when that's done will the SEC know, oh crap, XRP really is decentralized and we have a problem here. So it's really only at the end of discovery that I think it's a likely settlement scenario.
Okay.
2 months ago, there was a lull in the litigation, and I was wrong, I admit it, but it was an unprecedented lull, and I couldn't understand why there was a lull actually at the exact time that things should have been ramping up. And that didn't make any sense to me. So I threw out the S word, and I was a little premature. So, but then something was filed, and I was like, okay, that's fine.
Can happen to the best of us, right? I mean, you have a pretty high accuracy, so I'll let this one slide. Next one, we'll definitely catch you. So
get his slap on the wrist
a little bit. The Charles Gasparino thing. Do you think that the media coverage is important for the case?
So, you know, the federal judges are appointed, and so they don't have to win re-election. So they're not there for popularity, right?
Okay.
But at the same time, judges are people. You know, they put on their pants one leg at a time.
Lizard people.
So
yes.
When they see negative press coverage of the case, and you know, why is the SEC doing this, and they're destroying this industry, does it affect them? Yes. I don't think it cannot affect them. So although technically a judge is supposed to not be reading well, she could read it, but she's not supposed to take any of that into account. Only evidence in the record. Does it affect them? I think it does.
Okay. And then, okay. I see what you mean. So it does affect them a little bit, and they do, because people right now are really excited about it getting into Fox, for example, and because it gets a couple of articles into Forbes. So if it gets more mainstream media, it's not necessarily that positive, except for that the case just gets more attention. Then again, the judge, isn't there going to be extra pressure if like every major news outlet, for example, because of, for example, the Coinbase case, also look more at Ripple? She got extra pressure on her back, and thus will have to make swifter choices, for example.
I don't think she's going to move swifter. She's going to be more careful and more thorough. You know, like
then it's good.
I'm sorry.
Then it's a really good thing if we get more media coverage, right? Then
I think so. Look, if you're in a strong position, and I think Ripple is in the strong position in the case, I don't think media coverage showing that is ever bad.
Okay. Yeah, that makes a lot of sense, actually. Okay, then a overview. We just concluded. Right now, there's expert discovery, right? And I think it's already going on, right? So right now, until November 12th. So then they're going to file for motions for, can you just guide us through how it's going to work?
Sure. So no problem. It's even confusing for me still. 20 years. All right. So we finished discovery. And then at that point, the case is ripe for summary judgment. A summary judgment basically is where you move the court to rule on the case itself. And what you say to the court is, you say, court, there's no issue of fact for anyone to decide. We don't need a jury trial. This is something that you, the judge, can rule on.
Okay.
I think that the Ripple case is only going to be decided at summary judgment. I don't think there's a trial for Ripple. Now, I think there could be a trial for Brad and Chris, because in their case, what they were thinking and doing is relevant. And that's where you get issues of fact that a jury have to decide. But I think in the Ripple case, I think it's going to end at summary judgment. So what's going to happen is, after all the depositions are done, all the documents are gathered, the Ripple attorneys, all 20 of them, are going to put together a motion for summary judgment. I think that to speed things up, Ripple is going to move for summary judgment only as to current sales of XRP, current or future sales of XRP.
Current sales of XRP. Yes.
Yeah, I think that would make the most sense to me because of their business model. Now, I'm guessing here, but their business model requires liquidity in the markets, and it's been hampered because of this lawsuit. If they can get the judge just to rule on that one sliver of the case and say that current and future sales of XRP are non-securities, then that opens up Coinbase to relist and all that kind of thing. So I think that's what they're going to do. They could do the whole thing, but that would just mean it would just take longer, and time is money for them, right?
And does Ripple have like some inbringing and then the SEC too, or is it like Ripple just says, hey, we want to get a kind of a ruling on this, and then the SEC says, how does that work? Because you said Ripple just wants to ask like basically one question.
Right, that's a good question. So I think the way, no, it's a good question. It makes me think. So I think the way it's going to work is Ripple.
I got a lawyer to think, guys. I got it. Yes. Yes, good.
I'm going to send you a bill now.
Yeah.
I think Ripple is going to move on just that part of the case. And then once Ripple files their motion in federal court, you only have a certain amount of time to reply. And I think it's 30 days, or the judge might just frame it out for them. But anyway, they're going to only have a certain amount of time to reply. So then the SEC is going to have to reply to Ripple's motion. Now, if the SEC wants to try to get the whole case resolved, it would be on them to file their motion for summary judgment on the whole case.
Okay.
And then Ripple would have to respond to that. So if the SEC doesn't want just the sliver of the case only decided, that's how it would have to play out.
Yeah.
And I don't know how the SEC is going to respond if Ripple tries to get only this part of it decided.
We don't know yet. We don't know yet.
We don't know. So I don't know the answer to that.
In terms of time, again, how long is the expectation for anything like this?
So we have close of discovery early November. You know, the summary judgment motions are massive. And you could see from all the discovery stuff we've done so far, how long it takes. So I wouldn't expect motions for summary judgment to be completed until December at the earliest. I mean, to get these motions done within a month would be amazing, but I don't think it's going to happen. I think this is fully briefed out in December or January. And I think it's ruled on in February, March, early next year. But I don't know. It all depends. Sometimes these things take longer than you imagine they could. So I don't want to say December, January, because it could definitely bleed into 2022.
And I understand you fully. Then again, I think we also should, give the people some of their questions answered in the sense of how long could it take potentially? Because they're saying it's taking forever. It's never going to end. Is there like a max of like, let's say, for example, 5 years as an example, or is there like a more logical maximum that we can look forward to?
Yeah, the nice thing about federal court is they lay out a progression of the case for you, and I don't have it in front of me, but I think the trial date in this case is May, June. I think, just going from memory, I don't think it could go past summer 2022 at the worst.
Wow. Okay, I had no idea about that. Wow.
Yeah,
okay, really?
Yeah, the trial date will be set. The trial date was actually set back at the pretrial conference, but then it got pushed back because of the discovery bump down. So they're going to keep, I think the judge is going to keep them to that too. Now, here's the worst case scenario though, and maybe people are aware of this, maybe they're not. If the trial moves forward in this, let's say May 2022, both the losing party can appeal that.
Oh.
And then it goes to an appellate court to review what the judge did in the main case. that could take 9 months, maybe even a year.
Oh, that doesn't sound good.
Yeah. Now,
Ooh.
here's the thing, though. Here's the thing I would tell you. During the pendency of the appeal, so after the trial court rules, let's say the trial court says XRP is not a security, case over, get out of here.
Yeah.
The SEC doesn't like that, so they appeal. While you're waiting for the appeal, the ruling of the trial court is the law.
Okay.
So she says it's not a security. It is not a security as far
of
as
that point.
US securities laws are concerned.
Yeah. Okay. So
And then maybe, if the appellate court sends it back to her and says, no, you're wrong, that's when you have a big problem.
But that's again a future us problem, basically. That's not a problem just quite yet. The first thing is, of course, the judge, huh? And we'll see if they appeal.
So what I'm trying to say is, even if they appeal, because people are worried, what about the appeal? Yeah, there could be an appeal, but the law is the law as of when the judge rules on it until it's overturned.
Ooh, okay. Yeah, that sounds very logical then again, right? I mean, yeah, okay. So what would happen if the SEC actually withdrew their lawsuit right now? Completely different.
So the plaintiff in a case can always dismiss their own lawsuit. And I believe in federal court, it's just like it is here in Florida. So like when I file a lawsuit, I can dismiss it one time and refile it. With the caveat that if I refile it, I have to pay all of the costs of the other side. So the SEC would have to write a check. They could dismiss it if they wanted to, and they could refile it one time, but they'd have to write a check to Ripple for hundreds of thousands of dollars for the costs of the case thus far.
Hundreds of thousands, isn't it like very far into the tens of millions, you think?
It only costs, not attorney's fees. So the attorney's fees, I'm sure, is in the millions, but the cost would be like copies, expert witnesses, deposition, that kind of stuff. The
issues like when they say we have to print all the stuff out and stuff, like the research, for example. What was the most recent part? It was Ripple who had to the Slack messages, I thought it was, right? Where they're even looking for it now, if I'm not mistaken.
Yeah, they had to go back and I think that's the motion that I thought the SEC was going to win on, and they did. And then Ripple had to go back and pull up all these videos. They probably used an outside service, a third-party service. That would be a cost. So you have to hire a company, a data company, to go back and review all of your videos, and it gets expensive.
Yeah, but that was also negligence on Ripple's part, it said, right? And I already saw you say, indeed, that Ripple just made a big mistake, and so they're not looking too good for it. Yeah,
because their technology company that they hired kind of messed them up a little bit, because they didn't search something that they were supposed to search, and so it kind of made them look bad. Going in front of the judge, admitting that we were supposed to look for this, but we just forgot, and our technology company messed up. It's just a bad look.
Yeah, that doesn't sound indeed too good. Oh, yeah. So let's
especially for a technology company.
Yeah, that's financial technology. They can't do that. So to get the line out one more time for the people, we have right now, there's a lot of disputes going on. A lot of motions are still in the midst, right? They're not concluded just quite yet, but they will be most likely after expert discovery is finished November 12th. Then we get motions for summary judgment. I'm just seeing if I understand it properly, which can take a couple of months for this. Yeah.
I'm sorry, I got to back up because I forgot one thing. Before the motions for summary judgment can be ruled upon, of course, the judge is going to have to rule on all the motions to dismiss that are still pending. So those have to be ruled on first.
Okay.
And then she'll be able to hear the summary judgment.
And the other motions, like the motion to strike and the motion to whatever, all of those?
All of those motions that are still out there will have to be decided before summary judgment.
Okay. Okay. And that's like the meantime, most likely between November 12th then and the summary judgment thing, right? That's in the midst there.
I think that between November and the end of the year, there's going to be a flurry of hearings on all those pending motions to dismiss, motion to strike, fair notice defense, John Deaton's motion. And I think we're going to see a flurry of hearings with the new judge, the judge, so that she can decide on all those issues, because all those need to be taken care of right away.
It's going to be a busy month, huh? It's going to be interesting. Yeah. Oh, hopefully not around Christmas. No, I guess maybe as a present, maybe it's going to be some nice hearings for once. Yeah, that would be cool. So then, okay, to keep the conclusion going, so the people don't get distracted, because they will, and they will blame me for it. We have now discovery expert. Then all the motions need to be decided. Then going over into summary judgment, at least the motion for it. And then a decision has to be made within a couple of months, most likely. And then the decision is there, law is made, boom, pow, path, right? But like a maximum, for example, of July 2022, let's put it, broadly.
Right. So if the judge decides she can't decide certain issues at summary judgment, then those issues move forward to trial with the jury.
And
And I think that's in the summer of 2022.
And again, end date would be ish about
Summer 2022. I want to say it's May or June. I'm not sure.
Okay, but July is good as an end, as a most likely end, right?
But like I said, I don't think Ripple gets to trial. I think all of Ripple's issues can be decided at summary judgment, and I think they will be. And all the other cases that have been brought, like the Kick Interactive case, Telegram case, none of those went to trial. Those are all decided by the judge. And I think Ripple is going to follow suit.
Okay, in the same way. And then after that, which most likely, again, earlier is going to be fine and resolved, I would say the SEC is always going to appeal if they lose, right? Or do you think they might just skip it?
That's a good question. I haven't thought that through. My initial instinct is that the SEC would appeal a loss of the fair notice defense, because that would be a big one. If they lose that, basically they've lost their stranglehold on cryptocurrencies. Because if Ripple wins on the fair notice defense, almost any company that had an ICO in 2017 to present would probably win on the fair notice defense. So
they most likely, okay, they're going to come back for that one. Go on.
I think if Ripple loses, if the SEC loses on the whether XRP is a security or not, I don't think they appeal that, but I think they'd almost have to appeal a fair notice defense loss.
Very understandable. Very understandable. So then to conclude, your own personal expectation of when we'd be done, like a month or a 3-month period? Which 3-month period?
90% of cases settle at mediation. This is not a typical case though. So, most of my cases do not go to trial. I file 100 cases a year. I'm not sure, I'm just making numbers up, but I file 100 cases a year.
Okay.
3 or 4 of them end up going to trial. So that literally is how many of them settle.
Oh, wow.
This is not a typical case though. This is a big one, and Ripple has the money to fight them all the way to the end. And the problem we have with a settlement is that Ripple's business model requires certain things. And Ripple can't agree to settle on certain terms. And the SEC, of course, has their own agenda. And I think the agendas are not matching up at all.
Yeah.
And so unless those agendas can be brought together somehow, unless Ripple can agree and have liquidity, get an agreement that allows liquidity in the market, and the SEC can get whatever it wants out of this case, which at this point I have no idea, because the SEC is doing some very strange things. Who knows what their agenda is? Unless you can get those agendas to match, I don't know how you get a settlement in this case. So I'm trying to think it through, and I know most cases do settle, and you can have parties that are really far apart. I mean, I've been there before in mediation, and you think this case is never going to settle. He wants $1 million and they want to pay a dime.
Yeah.
And an hour later, boom, you're here, and somehow miraculously, I've literally settled a case walking out of the mediation building with the other attorney because our clients wouldn't agree. And somehow we're walking to our cars, we get the case. It's just weird how these things happen. But
damn. Okay.
This is a tough one to settle, I will tell you. But I still think that a settlement is the most likely end result here. And if that happens, it's probably going to be happening in December, January, February.
Okay. I think I completely understand. We have that area where it's most likely for a settlement. So I have the last 2 questions. The one regards to the settlement thing, which is Brad Garlinghouse in his letter to his employees, December 22. No, I think maybe 21, the day before it started, 2020. He sent to his employees, well, we could have settled, me and Larsen, beforehand, but we chose not to. And then later on, now to Gasparino, he also said again that they're not planning to settle. Are they talking about just Brad Garlinghouse and Chris Larsen themselves? Are they talking about Ripple in its entirety? Are those 2 things really like separate completely for a settlement, if you know what I mean? So like can Brad Garlinghouse himself settle now while Chris Larsen and Ripple fight on? If you get my drift.
Yeah, to answer that first question, absolutely. There's 3 defendants. Anyone could settle and the other 2 continue, or any combination. The other thing I would tell you is my understanding from that letter that they sent was that they were only referring to themselves individually. My understanding is that Ripple was never in a position, or never thought they were in a position to settle with SEC. Or maybe there was an offer, but they just couldn't agree to the terms. So I read that as me personally and Chris Larsen could have settled, but we feel very strongly about our position, and therefore we decided not to. So that's how I took that. And I think that, I think rightfully so. I mean, the case against, if the case against Ripple is here, the case against Brad and Chris Larsen is down here. I mean, that's a tough, that's almost impossible case to win. It's really difficult. And actually, I would not be surprised at all if the judge dismisses it here in the next couple months, because it's very difficult to prove people's thinking of why they do things. You know, it's almost impossible to get into their mind, and that's what the SEC almost has to do in order to win this case.
To completely get it through. Yeah, I understand that one too. Okay, I think I got everything around about the lawsuit itself. Let me see. I think we've covered all questions in my list from the lawsuit itself. Everything has been decided. A lot of people sent stuff in. Thank everybody for that one. We have one more very special question. And I know this is one that almost everybody has been waiting for. What is your price prediction for XRP?
You know, you could see the head and shoulder pattern.
Yeah.
No, I have no idea. I really don't. I don't pay attention to it. Look, what I knew was that the lawsuit was weak. I mean, what I knew was that the SEC had a difficult case to prove. I saw the price of XRP go plummeting. I bought it at that time because I knew that the price drop wasn't commensurate with the risk, because I thought the lawsuit was going to be very difficult to prove. I also looked up the old Kick Interactive case, and I looked at what happened to the KIN token after the lawsuit, and I was like, that's not too horrible. So I bought at that point, but I'm not a price guy. I don't know. I just talk about the litigation because that's what I do.
That's your thing. Do you actually buy dips? Do you actually buy, like, whenever, like now that XP went, for example, to 86 cents or 85, do you buy more?
No, I'm not that kind of trader. I don't honestly, I don't have time. I mean, that takes a lot of time to be, I know, I'm sure you do. It takes a lot of time, right, to follow what's going on and look at the patterns. And
I do it a lot. Yes, that's my thing. So yeah, I mean, I watch the news the entire day, kind of. So yeah.
Well, if you have any, if you want to just tell me what to do, I'll do it. But no, I don't follow it like that. I bought twice, and it wasn't on a dip or anything.
This is what I get every time, huh? I talk to somebody and they come ask me for financial advice. Even a freaking lawyer wants the dusty BC for financial. You guys see it? Again, we don't give financial advice on this channel. Never. And even this entire conversation here, nothing was legal advice. Not a single part. All right. Even though Jeremy Hogan, most likely very awesome in what he does, don't take any of this as legal. I'm pointing at people right now that can't see, but don't take any of this as legal advice. Just quickly putting the disclaimer there. But I guess one thing I can also ask about the price thing. Do you have any estimations of when you'd sell? Like, would you try to sell, bam, a settlement or a conclusion? I sell my crypto. I'm done with XP. I made money. Boom. Or are you thinking long-term utility? XP is going to be crazy, amazing, blah, blah, blah.
I think I'm like most people that are in the field, and I'm thinking long-term. I'm thinking that this is like the next internet. This is 1999, and we're looking at the internet. And when I buy XRP, I'm buying it for my kids, not for me.
Wow. Jeremy Hogan, everybody. So yeah, thank you so much for the amazing interview, man. It was nice finally talking to you. I've seen your videos so often, so it's really crazy to see you in the flesh like this, with as an actual human being instead of a robot that knows everything.
Yeah, same here. I listen to your videos. I like, all I know is the intro. This dusty. And I know you were in Amsterdam, and that was about it. So it was nice to meet you.
Yeah. All right, guys. So that was it for today's crypto live stream, I guess, huh? A little bit of a different thing. If you all enjoyed it, make sure you press that like button. Go check out Jeremy Hogan at Legal Briefs. I think that's what the channel is called officially, right? Legal Briefs.
Legal Briefs.
Legal Briefs.
Thank you so much, Dusty.
Yeah. Thank you for stopping by, saying hi, and I'll see you guys again in another crypto video.